You ever look out your window and get that weird feeling like, wait a second, is my neighbor's fence a little closer than it used to be? Yeah, you're not alone. It's that sinking feeling that someone's slowly, inch by inch, taking over your land, and you have absolutely no idea what the law says you can actually do about it. Well, today we're going to fix that.
Okay, let's just dive right into a classic scenario, right? Their fence is 6 inches on your property. Now, your first gut reaction might be to grab a shovel, maybe start a shouting match, but listen, both of those could land you in some serious hot water. So what's the right move? That's exactly what we're breaking down today.
You know, here's the absolute core of the problem. We all think of our property lines like these bright, bold, obvious boundaries, almost like a glowing line in a video game. But the reality? It's a completely invisible line. And that one simple fact is the source of pretty much every single neighbor dispute out there. Nobody really knows where their yard ends and the next one begins.
So before you do anything, before you even think about knocking on their door, your first, most critical step is to stop guessing and start knowing. You have to find that invisible line and make it visible. This isn't about winning a fight. It's about establishing the cold, hard truth.
And here's exactly how you do it. First, go dig through those closing documents from when you bought the house. Your property survey should be tucked away in there somewhere. No luck? Okay, your county assessor's office probably has a copy on file. But if you need undeniable, legally binding, court-ready proof, you gotta hire a professional surveyor.
And yeah, it does cost some money, usually somewhere between a few hundred and $1,000. But you gotta think of it as an investment. That survey, it's the one and only piece of paper that will actually stand up in court. Without it, you're just arguing opinions. With it, you are armed with facts. All right, so you got the survey, and boom, you were right. The fence, the shed, maybe even part of their driveway, it's on your land. Now listen closely, because this is the most dangerous moment in this whole entire process. What you do next decides whether you solve the problem or you become the problem. I want you to burn this quote into your brain. Imagine a judge saying this to you after your neighbor sues you and wins. See, being factually correct doesn't give you a free pass to take the law into your own hands. Not at all. Remember this critical rule. Even if your neighbor's property is on your land, you cannot legally touch it. Tearing down their fence isn't reclaiming your property. It's destruction of property. Taking a sledgehammer to their driveway isn't justice, it's vandalism. You'll be the one writing a big fat check at the end of the day. Now, if you can't touch it, you might be thinking, okay, fine, I'll just ignore it. Well, that is also a massive mistake. Because of this really strange legal concept, doing nothing can actually lead to you legally losing that piece of your property. For good. It's called adverse possession. You can think of it like squatter's rights, but for a slice of your yard. Basically, if your neighbor uses a piece of your land openly without your permission for a really long time, we're talking 5 to 20 years, depending on your state, the law might just decide that you didn't care enough to stop them. And now, that land is legally theirs.
Let me paint you a picture of how this plays out. So year 1, the shed goes up over the line. By year 5, it's still there, they're using it all the time. Now fast forward to year 15, all that time you did nothing. That inaction could have just morphed into a powerful legal claim for your neighbor. Every single day you wait, their case gets stronger and yours gets weaker.
So, you can't use force, and you can't do nothing. What's left? Well, there is a safe, legal, and effective path forward. It just requires a little patience and following the right steps, in the right order.
And here it is, your 4-step battle plan. Step 1, get your proof. That means the survey and dated photos. Step 2, just try talking. Seriously, have a calm conversation. Your neighbor might not even realize there's an issue. Step 3, if talking goes nowhere, you make it official with a certified letter. And step 4, if they still won't budge, it's time to let a lawyer take over.
And let's be super clear about that certified letter. It's not just a letter, it's a legal tool. That little signature they have to provide when they get it, that is your proof that they were officially notified. It tells a judge, Your Honor, I did everything I possibly could to be reasonable before I ended up in your courtroom.
So let's run through a few common scenarios real quick. Tree branches hanging over your yard? You can totally trim them, but only right up to the property line. You can't harm or kill the tree itself. Neighbor's fence on your land? You can't touch it, but you absolutely can build your own fence right on the true line. And for parking? You can have their car towed, but only after you sent that certified letter giving them a warning. And hey, when it comes to trees, the rule is ridiculously simple. It doesn't matter if 99% of the leaves fall in your yard. The owner of the tree is the person on whose property the trunk is standing. End of story.
So what's the one big thing to remember from all of this? It's simple. In property disputes, the person who knows the rules and follows the process, that's the person who wins.
Ultimately, you're at a fork in the road. You've got two paths. The wrong way, taking matters into your own hands and arguing, that path leads straight to lawsuits and fines where you are the defendant. The right way, documenting, communicating, and then escalating legally, it's a little slower, but it leads to a real resolution where you get your property back.
So here it is, your final protection checklist. 1. Act fast to stop that adverse possession clock from ticking. 2. Document everything. Photos, surveys, everything. 3. Always use certified letters to create that crucial paper trail. And most important of all, 4. Never, ever take the law into your own hands. Let the process work for you.
See, by understanding these rules, you're not a victim of uncertainty anymore. You're actually empowered to protect your biggest investment calmly and, most importantly, effectively.
Hey, if this breakdown gave you a little more clarity on your rights, do us a quick favor and hit that like button. And for sure, subscribe so you don't miss our next explainer.
We all know these disputes can get absolutely wild, so we'd love to hear it. What's the craziest property line story you've ever witnessed or heard about? Drop it in the comments below.